But on this courts of equal status with the High Court, I don't know that you can enrich your presentation by giving us data, maybe on full optimization of judicial human resource. If you pick maybe a place like, let's say, Siaya, for example, if you have a land court judge there or an employment court judge, and then you have a judge of the civil division of the High Court, how does the cost list look like? Are we making full utilization of a judge may be sent to Siaya to deal with employment cases, which I think may not be many, so that we just do a comparison and see, or somewhere like Kwale or Kilgoris. I'm sure in Nairobi it could be different, but maybe we can see how the situation looks like in those remote courts. I fully support, Chairman, the idea of qualification for judges. Doesn't make sense for a judge of the Court of Appeal to have the same experience like a judge of the High Court. So I'm in full support. Supreme Court judges likewise should have a lengthy experience, either in academia or in practice. Now, where I differ is, I don't know where you are coming from, the request to increase the number of Supreme Court justices from 7 to 11, because the jurisdiction of the Supreme Court is fairly limited under Article 163. If you look at Modomi Tiankol may agree with me, if you look to other jurisdictions, USA since 1787 has just had, I think 9, if I'm not wrong, a population over 200 million, wider jurisdiction, 9 judges, they have never increased. Australia, the equivalent of Supreme Court, I think, is the High Court. That's the highest court. Australia, they call it the High Court. It has got, I think, if I'm not wrong, 7 judges. I will want to be convinced, really, why, with that limited jurisdiction, the Supreme Court would want their numbers to be increased. Maybe what we need to think is whether we need to borrow what's happening in other jurisdictions, like Uganda, where the Chief Justice does not sit in the Judicial Service Commission. We take away the administrative duties. You know, if you go to the UK, where we really borrowed our, largely the chapter on judiciary, especially on Judicial Service Commission, out of the 15 members of the Judicial Appointments Commission, only 3 judges sit, because judges are left to deal with dispute resolution. Administration is for what you are proposing. Maybe retired judicial officers should take those slots. So maybe I think what we need to think about more is relieving the CJ from administrative duties so that she can put more time on a dispute resolution. That will be my take. And then finally, I agree with Mheshimiwa. We cannot take discipline to the peers. You know, we cannot say discipline of Supreme Court judges should only be for Supreme Court judges. I think once we give you a Judicial Service Commission that is independent, that should be able to deal with issues of discipline. The only confession I want to make is that I contributed in throwing in a magistrate as a member of the JSC, because when we are discussing the composition of JSC, LSK was left out. So we made a case that magistrates also need to come in. But I hear the point. I think, Chair, the point I've picked is it looks awkward if a Supreme Court judge is appearing before JSC and the person listening to the disciplinary proceeding is a junior officer in the magistrates. I think that's food for thought. You have made a strong case for me, even for interview. You know, if a judge of Supreme Court is facing an interview to become a Chief Justice, maybe it doesn't look very nice that a magistrate sits. That's food for thought. You have left me with something to ponder and think about. But this is a very good piece.
Something to undo what you did.
I think so. Yeah, those were tough times. Yeah, but I think everything here looks good. I think it will enrich our discussion on this chapter of judiciary. Thank you.
Thank you. And then, just finally, when you are responding, again, make a formal submission in terms of what are the kind of qualifications you see at each successive courts. I think but if you tie this qualification so high, I remember the Chief Justice of the United States was appointed Chief Justice at the age of 54, John Adams. He's actually aging there. But I agree with that idea. When you visit the Supreme Court, you should look like you're going to a shrine with Lord Denning type of people walking with robes. You don't look just discussing law. Yeah, but also we need to draw the balance. But give us the actual cutoff of those age limits. Those professional limits.
Thank you very much. Let's have a response in less than 5 minutes, please, if you can.
Thank you very much, honorable chairs and members. The issue of discipline, I think Honorable Mugeni has alluded to it. I think there is just the awkwardness we are talking about, the awkwardness of the panel. And so the idea is to be able
Go ahead.
Thank you very much. I just paused to recognize the presence of the Honorable Kalonzo Musyoka. Thank you very much. So it is the awkwardness, really, and the idea that we want a process where the judges will feel comfortable and accept the outcome, not in a place where you feel that I was presided over by a junior officer, and therefore, you are put in a very awkward position. And that explains why we are recommending that if we have retired judges, because these are people that are respected, they would be able to have that sort of gravitas to be able to answer to this question of awkwardness and a sense of accepting the outcome of the process. The issue of the timeline from the 14 to 30 days, the main reason really that has been given, and I'm happy that the members are clear for them that if the verdict is given, they have no problem. But what we have found on the ground is that there's a sense of, from the public, that there's a lack of accountability. So the feedback we have gotten is that there's a sense that in which the court is not being accountable, and some people may think that there are shenanigans, that are happening. And so the basis of the recommendation, therefore, was that if the court can have adequate time to finish the entire process, so that at the end of the process it is known it has taken 30 days, the verdict has been given, the reasoning has been given, and therefore we have finished this. So the 16 days is a time for a lot of speculation and issues going around. So that really was the basis. The issue about the courts, Honorable Wandai, you asked, yes, 140 courts are not adequate. We had a very successful program of the World Bank, which ended 2 years ago. We were able to get funding that helped us build and refurbish 29 courts. But after that now, we are fully dependent on government funds to be able to build the courts. So the other mechanisms that we are putting in place, we have got quite a few engagements with members of parliament. Some have been very magnanimous, using the funds that are at the constituency level to help us build courts. Others is the county government. So that is the mechanism that is in place right now. But as you pointed out, these courts are still way below what's required. Many of them were built in the colonial era, and so they do not meet the specifications for access to justice for our Kenyans. Honorable Omar, you mentioned about functions for the DCJ. We are going to provide that. We are going to provide some recommendations on some of the duties. The question about the overpopulation of the JSC with the judges and therefore being too lenient, far from it. The Commission has actually come out very strong in some cases. In fact, in some matters, the Commission has moved on its own motion to be able to get some judges to face the Commission. And so the issue of leniency really would not apply in this particular case. The issue of the Chief Registrar versus the Secretary of the Commission, starting with the JSC. The JSC superintends over discipline issues, so it means there is a very proactive role it plays in just, and it's not just for the judges. It also superintends over discipline cases for judicial officers and staff when that is brought now from the judiciary. From the human resource management perspective, the lower staff, but that is not at the hearing and all. But that responsibility is with the Judicial Service Commission. Policy direction is the Judicial Service Commission. So the responsibility is quite a handful. The Chief Registrar, on the other hand, is responsible for the day-to-day operation of the judiciary. We are talking about a staff complement of close to 7,000. So looking at just the human resource, managing the finance, managing the procurement, it is a very difficult job. And thank you, Honorable Omar, for your commendation that as the deputies, we sit there to help. But I can tell you, if it is just one individual, it is a very arduous and an uphill task. So the proposal to separate is so that there can be better efficiency in the operations of both the Commission and also the judiciary. Honorable Mbilianga, you mentioned about alternative ways of resolving. I'm happy to report that we have been increasing our resource allocation towards court, the alternative justice systems, and also the court-annexed mediation. So it is our priority under Article 159 to ensure that other alternative forms of justice are also given room, and we are continually assessing our performance, increasing the mediators, and also looking at those systems to see how then do we increase. So that is something that is really at the forefront of what we are doing. Honorable Mogeni, thank you very much for your commendation and appreciation. And the reason you asked about the performance of the courts of equal status in some of the counties and far-flung areas. You will find that in some of the areas, the Chief Justice has sent a judge, for example, an employment judge, and this happened actually in one particular county. One was sent there, but within less than a year, all the matters had been concluded. And so what the Chief Justice did was to redesignate that person to go to another town altogether. And this is the reason why we are saying that if the jurisdiction of these judges can be increased so that then the Chief Justice can freely deploy judges to where there is need, then they can apply they can apply their skills and their experience in whichever location that has that particular need. On the question of the Supreme Court, the numbers, I think you asked and then you very graciously started answering the question by pointing out that both the Chief Justice sits in the Commission as the chairperson, which has a very heavy mandate. Then we have an extra judge from the Supreme Court who also sits in the Judicial Service Commission. And therefore, when you have 2 out of the 7, it means you only remain with 5. When you have those 5 and the quorum is 5, if anything is to happen to any of those 5, then it means some matters may not proceed. Of course, the Chief Justice and the other representative does not sit all the time in the JSC. They also try to regulate their calendars to be able to sit. But we are saying in an optimal situation, it would be good to have this additional 4 members so that you can constitute 2 benches. And if there is any issue, one can recuse themselves comfortably. My colleague from the Supreme Court, I don't know whether you'd have anything you'd want to add on that? The DR from the Supreme Court?
Thank you so much.
Well, just 1 minute.
Yes.
Yes.
Thank you so much, members of the committee. I only wish to add a point to the issue of increment of the numbers from 7 to 11. I will draw the attention of the committee to a situation that occurred sometimes back when Emeritus Dr. Mutunga was almost leaving office. There was almost a crisis in that court based on the issues that arose. And if it would not have been for the matter to be settled amicably, there would have been no quorum. So the Supreme Court for the last 10 years has sat at 7, and the experiences that the court has faced, they have not been that pleasant. I sit in that court as a case manager, and part of my role is to ensure that if a judge now sitting at the Supreme Court ever sat in a matter at the High Court or the Court of Appeal, will not sit in that matter. Sometimes you find 3 sat, and therefore the quorum is not sufficient. And that is when the Supreme Court itself decided to come up with a decision on the doctrine of necessity. So on that basis, that is where the Supreme Court comes from in making this recommendation for 11. So anything can happen, and the Supreme Court will want to caution itself from embarrassment that it has not been able to hear a case.
Asante sana. And then when you are giving us your further submissions, just tell us whether or not your part of the recommendations you're putting forth will require a referendum.
Thank you, Chair. We note that. We'll do that.
Okay.
There is one question you asked. I don't know whether you'd like me to answer still on the qualifications for judges. I think what we are recommending is really experience. So when you look at 10 years, I'm talking about the experience. We are not looking so much in terms of what specific qualifications. We take it that if you've done 10 years, there is a level of experience you have, 15, 20. The qualifications are more or less the same, but the experience that has been garnered as a practicing, judicial officer or an academician or a legal practitioner, then is what matters. Thank you.
Thank you very much. As you were concluding, we were joined by senior counsel who you acknowledged, who is also the delegation leader and co-chair of this forum, His Excellency David Kalonzo Musyoka. So,
just 1 minute. Are you able to give us the number of cases that the Supreme Court handles in each financial year?
Yes,
the appeals filed before the Supreme Court,
yes,
the determinations on each financial year.
yes.
Can you give us that data?
Yes, we can provide that.
Okay.
Asante sana, Ndemo, and your team. We are very grateful for your presentation. As Senior Omugeni said, it actually pointed itself to the issues that are very specific to the own operational and challenges and issues around the judiciary. Asante sana.
Thank you for having us. Thank you.
I had to get here so as to strengthen our type of bench. And we thank you for entering appearance. We value your contribution. And I thank you.
Thank you, sir. Okay. You are recused.
Thank you very much.
ICJ is next. ICJ is next and the last for today. This way.
So that we don't hear just one side. If there is anybody from civil society, a lawyer,
several proposals by various stakeholders on the time of the hearing on the end of the day.
but you have interest to just focus from the other outside of it. And if there is a lawyer also, academia.
First and foremost, is to welcome you to this sitting. Grateful to have the ICJ as usual to speak to some of these matters of national importance. We have our Member of Parliament there, Amina Mnyazi from Malindi, who's a member of this committee. We have Honorable Opio Wandai, who is the Deputy Delegation Leader, Minority Leader, and a member of this committee. Honorable Senator Okongo Mgeni, and Senator Nyamira, Senior Counsel, and a member of this committee. We have my dear sister, Honorable Catherine Mobilianga, Senior, you know, I'm talking to lawyers, so I was about to tell you, she's...
Senior KNUT.
Senior KNUT. Okay, senior teacher. She's also the women rep for Bungoma and a member of this committee. There's an apology from our Deputy Delegation Leader, Honorable Cecily Mbarire, who's out of town attending to business of the Tourism Week. Senator Aaron Cheriot is in Turkana for inaitwa nini, Senate Mashinani. I'm sitting in for Majority Leader who you saw here a while back, who is in Parliament, the Senate Honorable Isungwa, and I'm Hassan Omar, MP Yala. So over to you, Bwana Idi.
Thank you very much, honorable members. Your Excellency, Stephen Kalonzo Musyoka, the co-chairs and members of the Secretariat. In front of you is ICJ Kenya, and we, first of all, like to appreciate this opportunity to address the National Dialogue Committee on these very important issues. We could not miss the opportunity to give our opinion, the opinion of our jurists, our members, and of the sector regarding issues that have been outlined.
You introduce yourself and the team.
Yes. In front of you is Mr. Shukri, Mr. Jaika, and Ms. Wayua Wadeka. They are all members of staff of ICJ Kenya. I am Dimas Kiprono, the Deputy Executive Director of ICJ Kenya. I send apologies from our Executive Director, Elsie Saina, and our Council Chairperson, Mr. Sainde. And so our presentation will be in line with the invitation that we got from the National Dialogue Committee on the issues that were outlined, namely Article 43 of the Constitution and the cost of living related issues, outstanding constitutional issues, electoral justice and related matters, entrenching funds into the Constitution, establishment and entrenchment of state officers, and fidelity to political parties, coalitions, and democracy. And so we will hand over an abridged version of our presentation, and we will send over a longer version outlining all our positions in the outlined issues. On achievement of Article 43 regarding cost of living issues, the right to health, housing, and so on and so forth, Our first observation is that there has been a problem in terms of what roles the national government and the national and county governments have in terms of achieving these rights. A good example is the right to health, where we find there's a lot of duplications of roles between the national government and county governments, thereby occasioning a lot of wastage of our public funds. Another issue we have earmarked is corruption, and our assessment is there is generally a lack of political will to deal with corruption, to give the institutions that need to be given independence and resources what they need to investigate and adjudicate corruption. We also find that there are issues in terms of who ends up in certain positions that are crucial in the fight against corruption, in terms of in the criminal justice system and so on and so forth. And so our recommendation there is we look into how we inculcate leadership and integrity to ensure that those that we put in to ensure that corruption does not happen in Kenya are the correct people. Another issue we earmarked is irresponsible borrowing. And here we don't have much to say except that there needs to be transparency in terms of how we earmark projects, fund them, and whether we have ways ensuring that they are that what we earmarked as money that we borrowed goes to the right thing. There's also an issue of government wastage generally. This, again, is underpinned by, as I said again, the duplication of roles between national and county governments, where we have a national government that wants to cater for healthcare issues. At the same time, we have counties that are actually constitutionally mandated to handle healthcare issues. And part of the recommendation here is that the National Assembly and the Senate come up with clear and concise laws that demarcate the roles between national and county governments. And not just that, after that is that to ensure that the various bodies only do what they are required and what they are allowed by law. After that, I'll skim through to the issue of the 2/3 gender rule under the outstanding constitutional issues. And here we don't have much to say except that I think it's a very important constitutional tenet that we gave ourselves in the 2010 Constitution. And we have had various attempts by Parliament and also opinions by courts that have buttressed the need to have the 2/3 gender parity. Here we give the example of the judiciary, where if you look at the number of magistrates, right now their gender parity is 53% women as opposed to 47% men. Overall, from the Supreme Court to the magistracy, you'd find that 47% are women. And the Judicial Service Commission itself has declared that their aim is to reach a 50-50 parity. This illustrates that it is possible to have gender parity or to honor the 2/3 gender rule as per required by our Constitution. And so, how do we do this? We see that the Parliament has made several attempts, the latest being the Duale Bill, and we opine that the Supreme Court has spoken in terms of Parliament cannot sit properly and sit pretty, that it is properly constituted when we do not have the 2/3 gender rule. As such, it is actually the imperative of our legislature to come up with a formula for elective positions. That said, that does not prevent Parliament from also coming up with legislation on gender parity or two-thirds gender in terms of appointive positions. As I've said before, this has been possible in the judiciary. It can be cascaded through the county governments, the national government, and so on and so forth. The next issue I will jump to is the issue of national inclusion. Just to note that political interests, patronage, nepotism, tribalism has bedeviled this country since independence. What informed the 2010 Constitution in terms of its aspirations under the public service provisions under Article 232 to ensure that part of public service is our national diversity in terms of ethnicity, regional balance, and so on and so forth. However, this has not been the case in the national government, in the counties. And we have come up with certain recommendations. We have also decided to perhaps shine a light on the Public Service Commission itself, which is charged with handling the public service in terms of advertising, selecting, interviewing, and hiring. And they have not felt the heat in terms of how certain appointments happen that really do not abide by our plurality as a nation, that everyone from every part of the country should be represented in our public service. And so I think Parliament should find a way in perhaps holding the Public Service Commission more accountable. Apart from that, we should also embed inclusion as part of the performance contracts that most public service officials hold, so that every year you have to show that you have not brought the village to your office, instead that you have brought Kenya to the office to serve all Kenyans. I think going forward we need a proper national audit to ensure that we know which offices, which sectors need some sort of corrective action to ensure that we have the face of Kenya represented in our public service. And I think we should also empower the National Commission on Integration to have some enforcement powers, so that they are not only there to give us data, but there are things that they can do to ensure that that our national and county offices are reflective of the whole nation, including vulnerable people. I'll jump to adequate checks and balances. The Constitution was a resolution by Kenyans to have separation of powers, and part of it was the removal of certain functions from the executive. It also ring-fenced the space of the judiciary, and also to ensure fairness and to ensure that everyone has a say in decision-making, devolved power to the counties. However, since 2010, we've seen an onslaught on constitutional commissions on the judiciary. For commissions, it's come through budget cuts. It's come through outright refusal to replace commissioners. Sometimes it has come through other challenges. For the judiciary, we all know that there have been attempts to amend the law to give the president more leeway in appointment of the Chief Justice. There have been refusal to appoint judges. There have been budget cuts. And so basically there's no real magic bullet in terms of checks and balances, other than fidelity to the Constitution by all actors. Parliament should stick to its lane, the executive should stick to its lane, and we also join the judiciary in praying that they also have an enhancement in terms of their funding. I think currently they sit at 0.6% of the national revenue, and they should be around 3%, 3.5% as earlier espoused. I will jump to the electoral justice part. From our point of view, IBC has really suffered from political sabotage ever since we passed the new constitution. We've had politically instigated removal of officials, and then subsequently we've had officials being, vacancies not being advertised by the appointed bodies that are supposed to do that, leaving the commission to sit without commissioners for a long time. And then we've had appointments that come in too quickly towards an election, so that the commissioners really have not really occupied that office, do not know what is going on. And as such, we've had a situation where there's little faith in the IBC. So I think we have outlined some So our recommendations is the appointment of commissioners should be made at least 2 years before the general election. Equally, we think there should be a mechanism to stagger recruitment of commissioners, so that at no point do we have a commission that has no commissioners. And then establishing clear roles between the commissioners and the chairperson of the commission, as recommended by the Supreme Court in the presidential petition last year. And also adding the period for hearing and determination of the presidential petition from 14 days to 28 days. On boundary delimitation, we acknowledge that it is a very important facet of our democracy, and we opine that Parliament should enact a separate law dealing with boundary delimitation, separate from how it sits under the IBC Act right now. That is the main recommendation there. With regards to the entrenchment of funds under the Constitution, we are again guided by the Supreme Court that found that the NCDF is unconstitutional because it sort of entangles the legislature into expenditure of funds that are not contemplated under the structure of government as we have it. And so I think if the funds need to go to the people, it needs to go either through the national government directly or through the county governments. If it is bursaries that are needed, bursaries per constituency may be earmarked at the county level. Equally, we find that the Affirmative Action Fund and the Senate Oversight Funds may also muddy the issue in terms of on separation of powers. Especially for the national government Affirmative Action Fund, women representative is a member of the legislature and should not be involved in oversight of any funds, which, again, as I said, should go to the county or the national government. Establishment and entrenchment of state offices. We note that both the Prime Cabinet Secretary and the leader of official positions are not there in the current legal framework. we suspect that as it is the Prime Cabinet Secretary, because has more powers than other ministers, is not an office that is as contemplated under our constitution and is therefore probably unconstitutional. And if they are going to be embedded into our constitution, they would need a referendum under the guidelines of Article 255, 256, and 257, and the interpretation of the Supreme Court judgment in the BBI case. I think in conclusion, basically we're saying that we appreciate what has led us to this process, to the National Dialogue Committee that has actually stopped a spiraling of the situation as we saw earlier this year. And we appreciate that there's stability in this country, and that perhaps the problem in Kenya is not a political one, is not a constitutional one, it's mainly a political one. And so we urge the committee to, first of all, really reflect on implementation of the Constitution as is, because most of the issues outlined have to do with lack of fidelity to the Constitution itself, rather than really problems with our laws. Thank you.
Thank you very much, ED, Deputy ED. I think I will, it's been the practice of this group, this committee, we allow a couple of interventions from our members. We hope we will keep them brief.
Yeah, I could, let me be the first to go because I was the last to come in. First of all, your document is not signed. It's an oversight. It's very unusual for body as respectable as ICJ not to give us a document which is not signed. I would urge that this be done.
Duly noted.
Secondly, well, this question perhaps should have gone to the team that was before you, the Judicial Service Commission. But allow me to pose it to you, because you're literally birds with the same feather, a lot of us here. It has been argued that, by some who appeared before us, that the 14 days within which a determination should be made in case of a presidential petition are sufficient, because the nation at that particular time is on its tender hooks. So much emotion, so much sense of expectation, and possible explosions, political explosion, that the matter should be dispensed with expeditiously. And I think that is perhaps why in the petition I was actually, although people never seem to know this or remember this, I was actually one of the appellants in 2013, and I think again in 2017. But my friend Raila is always quoted the Raila petition, but that is okay. Then judges, as in the case of Chief Justice Emeritus and his team, Willie Mutunga, to date, I don't think to date that judgment is quoted anywhere. I know the position the ICJ took and other legal bodies, because they said we will give our judgment and follow with the reasoned, with the reasons. And the judges of the Supreme Court, we've actually even had, and this I find very interesting, the judges of the Supreme Court should be increased to 11. I find that proposal very, very interesting. I would want to hear the views of ICJ on that, And the team before you, Judicial Service Commission, opined that the period within which this matter should be determined should be within 30 days. I had you pronounce 28 days. A day in a presidential election petition is a very important thing. And they say 1 day in politics is also critical. A week in politics is very, very critical. So the difference between 28 days and 30 days could be very interesting, or indeed 14 days. We would want you to guide the thinking of this committee in this very important matter, because it does fall squarely within the province or the mandate of this committee to be able to make recommendations. Therefore, I thank this ICJ. In your presentation also, you said that the Commission, IBC, has suffered injustice in many ways. Removal, according to your presentation, of IBC Secretariat staff. And where I'm coming from, in Nakuru, the Prime Cabinet Secretary was even referring to killings like of Chris Musando, which I found very, very interesting coming from him. There are those staffers who have been killed. But then, in your written submission, you talk of politically motivated removal of commissioners themselves. But in your verbal presentation, you ignored that. Is it a slip of some kind? Is it, or is it that you are thinking more in terms of the staffers as opposed to political removal of? I'm referring to page 6, I think it is, on electoral justice. This can be demonstrated through politically motivated removal of commissioners, failure to appoint competent commissioners, and all of that. And therefore, we take opinion by ICJ very seriously. I personally do take patient of this. And we therefore chose to invite you and thank you for coming. But those are my initial comments, or indeed, I just wanted to posit that as a matter on which you can give us further reflection, one or two issues, so that we can make this country better for all of us and for future generations. Thank you.
Keep it very brief, please. The 4 of us have been here since 10.
Okay.
9.
You went without lunch, did you?
Yes, 9 from 9 o'clock.
Yeah.
Mm-hmm. Oh, I'm sure you beat something.
You
right?
did indicate you will send us a detailed brief. I want you to give a suggestion on a solution to the problems we have. You have mentioned that we should periodically do a national audit of ethnic and regional composition of public officers. We did such an audit on recruitment of KRA staff at Senate. We found the ethnic imbalance, but we really don't have a solution. Can you enrich your document and maybe make a proposal? What should be the consequences? Then number 2, page 7, you have said we should establish a clear role between the commissioners and chairpersons, and the chairperson of the IEPC Commission. What are you having in mind? If you read maybe Article 138 on tallying and verifying the election's outcome, how can we distribute these roles so that the commissioners feel that they are part of the commission? Do you have any suggestion? Finally, at times you are the ones who lead litigations in court on public participation. You can see the last page you have said these discussions should be people-centered and not just by politicians. From where you are sitting as ICJ, Are you satisfied with the process that we have undertaken at Bomas? We have invited the public, they have presented their views. Do we meet that standard of people-centered process?
Thank you very much. When you say that we need to expeditiously appoint the commissioners on the basis that we are crippling these institutions, part of what has delayed this process is actually the work of this committee. In your view, how urgent is that reconstitution of IBC? And do you support the panel process, or do you have any particular suggestions as to how the commissioners can be appointed? You can say something.
My colleague Julie will start with the responses.
Thank you very much, chairpersons. I want to recognize the presence of a few ICJ Kenya members on the panel, but I will not name names. So thank you for the opportunity to present. On the oversight on the signed document, I agree. It was a complete oversight. We will make amends, and the full document will be signed and stamped. On the question of the 14-day issue, it is actually something that we began conversations about prior to the 2022 election. We thought, in our opinion, that as per the draft of the Constitution, I think we had envisioned having either 1 or 2 petitions at the Supreme Court. But I think 2022 showed us that there is potential for more. So having 7 petitions before the court with a time limit of 14 days is not reasonable. And with that, we'd hope that that can be considered. So either 2-pronged conversations. We either limit the amount of people who can petition before the court during that process, 1, or we extend the number of days. The number of days would allow the petitioner sufficient time to even gather their evidence, because we saw that as a big challenge because of the timelines as well as the scrutiny process. And I think that would be better addressed with an extended amount of days. 28 days is not ideal. I don't think we will get to an ideal number of days in Kenya, because any lawyer will give you a reason for 60 days, 30 days, 28 days, or 14 days. But from our submissions, I think 28 days would be ideal, because it would be a double, but it's also something that we can discuss, and the wearer of the shoe knows where it hurts. So if the judiciary is proposing 30 days, I think we are also amenable to consider 30 days. On the conversation of increasing of judges, I think we have actually been at the unfortunate draw of a lack of a quorum at the Supreme Court. And I think it's something that ought to be considered. Increasingly, we are having a lot of matters that need the Supreme Court's interpretation and guidance, all the way coming from all the courts of equal status at the High Court, but also the Court of Appeal because of the appellate nature of our processes. And I think the Supreme Court needs more judges. However, the balance as to 9 or 11 is something we ought to discuss and ought to engage in further research because of the merits as well as the budget implications of increasing the numbers. There is a budgetary implication to a Supreme Court judge. So I think that is something that requires further research. As ICJ Kenya, one of our approaches to our work is research. We can undertake to do that research. We do not know whether we will comply with the timelines of this committee, but I know that that is research that we can undertake to see where Kenya ought to be in terms of representation at the Supreme Court, in terms of numbers, appreciating the extended role of the Chief Justice and also the role of the judge who sits as a commissioner of the JSC. Also going into the conversation around the reconstitution of the IBC, I think in regards to the fact that we already have a selection panel that is in place, and they are per se waiting for the decision of this committee to continue with their work, because we do not want to do the process all over again because of the recommendations of this committee. It would have been ideal if this committee had sat first before the selection panel had been constituted, but that would be an ideal situation. But we are where we are. And I think one thing that we could recommend to this in the longer version would be a broader inclusion at the selection committee. We know that there is no civil society represented at the selection panel, which I think is a really grave oversight. We can organize ourselves as civil society and bring forth a name for consideration with both male and female for voting if need be. But I think that is a grave oversight. The law society is represented, the religious community is represented, but civil society who actually represent the voice of the people are not at the table. And I think that was a very grave oversight. So ideally, we should consider reconstituting the panel. In regards to having more political party representation at the selection panel, I think one thing that is actually a conversation and a cause of concern is the fact that IEBC needs to be independent. And the people who select the IEBC commissioners matter just as much as the IEBC commissioners. So we cannot have a situation where the selection panel looks very leaning to the political class, because it will create the same narrative that we already have, which is political mistrust, public mistrust in the IEBC. So I would implore this committee to really consider reconstituting the selection committee, because how you create the selection committee will actually dictate how Kenyans will perceive the commissioners who come into office. I thank you.
I think we're okay. Thank you very, very much, ICJ, and thanks for the support to governance work, to the support to public interest litigation, to a lot of the support you have even given us individually and collectively as a society. And I do take kindly the words that we have to get civil society involvement in part of these processes. But just do suggest to us how that is done, because civil society is such a broad animal, and therefore we want to know. LSK is very specific, IRC is very specific, and religious council, state institutions or independent commissions are very specific. What is civil society in terms of representation? A proposal will suffice. Thank you very, very much. You're also recused. Just for the attention of Imogen and the Secretariat, Governor Barire has said that the COG has requested that I've said they've been recused. I was speaking as they're walking out. So Imogen, they were requesting that they be heard at 2 p.m. on the basis that an alternative time, because at 8 or thereabout they've been summoned to attend a meeting, yes, at the Deputy President's office in terms of IBEC, I think. So they asked for 2 p.m. Yeah, or an alternative time that would work. The morning is where they are slotted for, and unfortunately they have to attend a meeting at the Deputy President's meeting.
But we have got people appearing virtually at 2.
You can do it then after that virtual appearance. I can communicate to Cecily about that. I think we will communicate to us. Thank you very much.
Yeah. We hear them on
I think since the governors will be in town, let's take advantage of them when they're in town tomorrow. Yeah.